to the fellow commissioners, to staff, and to the Columbus residents for their time and energy and effort toward this initiative. Today, we will be holding two meetings. The first is this working meeting where we will consider proposed charter amendment language, and at 5 p.m. we will hold a public comment session, and speakers' slips will be accepted until 5:30 p.m. Do any of the other commissioners have any comments at this time? Thank you. We will move on to the approval of the minutes. Do any of the commissioners have proposed changes to the minutes? Commissioner Curtin?
Madam Chair, I have one. It is the bottom paragraph on page 2, where it states, Mr. Curtin stated that he was not uncomfortable, and that should be changed to not comfortable, or remove the not to make it uncomfortable. It's a double negative, and the sentiment was not moving forward as long as we had division on the commission on that question. So not comfortable rather than not uncomfortable would be the change.
Thank you very much. Any other proposed changes to the minutes? I have just, I'm sorry, Commissioner Dorian, I'm sorry, I didn't see you.
On page 5, I believe this is just a typo. It's the 1, 2, 3, 4th paragraph from the bottom of the page where it talks about Mr. Cabot, etc. Look at the third line. I think it's a typo. Mr. Cabot asked if the state statutes or statutes. Probably meant statutes, didn't you?
I did.
Might be a few statutes over there. That's all I have.
Thank you very much. And I have two additional proposed changes. On the first page, in the third paragraph down, that starts with Auditor Dorian, the date should be changed from April 25th to June 11th. And then on page 4, in the fifth paragraph down that starts with Mr. Clark, it indicates that the one-year residency requirement was removed. I believe that issue was discussed and will be further discussed at this meeting, so I would like that correction to be made.
I wasn't able to hear what you said.
Sure, I apologize.
Sorry.
On page 4,
Right.
in the paragraph that starts with Mr. Clark, that's 5 paragraphs down,
Yep.
it indicates that the one-year residence requirement was removed and instead kept at the provision of the charter that an individual running would need to be an elector of the city. I believe that issue was discussed and it's going to be further discussed today, but not that a decision has been made to remove that. But that was my recollection. Does anybody remember that discussion differently?
Not concur with.
I was willing to accept it last time, but I'm willing to reconsider it and accept it again this time.
Fair enough. Thank you. My recollection is just that we were going to further discuss it, so I appreciate that. Hearing no other corrections, I would entertain a motion to approve the minutes as amended.
So moved.
We approve the minutes of June 19th.
Thank you. Is there a second?
Second.
All in favor?
Aye.
All opposed? Motion carries. Thank you. And now we'll ask for a summary of public comments received to date.
Thank you, Chair Moore. The Secretary of the Commission will be joining us. She's running a couple of minutes late. We have not received any additional public comment beyond that discussed at the previous Commission meeting.
Thank you very much. I appreciate that. We're going to move on to the first proposed charter amendment language that we'll be looking at today, and that is on the subject of elections. We received a presentation on June 19th, but there was some further discussion was needed, and I will now turn to staff to please brief the Commission on the proposed language.
Thank you, Chair Moore. If it's okay with the Commission, what I'd like to recommend is that as we go through the summary of recommendations, which tracks the language that you have in front of you as well. If there are any comments, questions, concerns, please feel free to stop me at any moment because we do have a lot to wade through here. I would also note that to make discussion a little bit easier, the version of this amendment that you have before you is laid out with line numbers to the left-hand side for easier reference as we go through this discussion. So I would begin by saying that staff's recommendation is that we explicitly state in our charter that all of our elections would be conducted under general laws of the state unless provided by the charter or by ordinance of council. This would give us some consistency and predictability following state law, but also give us full access to our home rule authority with regard to charter provisions, and also should there be a need to establish, for example, a penalty for a violation of a charter provision, give council the authority, the express authority, to enact that sort of penalty. Secondly, we would recommend maintaining the nonpartisan elections by secret ballot that have been the hallmark of Columbus elections since our charter was first adopted, and maintain every citizen's right to vote for every elected official in their city government. With regard to campaign finance, as we discussed previously, there was a charter amendment in 1995 that would expressly allow the city to enact campaign finance reform. At that time, the focus was primarily on limitations on monetary contributions to political campaigns. In the intervening years with Supreme Court rulings and the general mood in Congress and nationally with regard to campaign finance, staff is recommending that we affirmatively state in our charter that we can also pass ordinances with regard to disclosure requirements for contributions. That's something the city has already done, but not something that is expressly stated in the charter. And that also we expand this authority to include ballot issue in addition to candidate campaigns. The purpose there being that impact on an initiated ordinance or charter amendment can have just as much of an impact on our city as the election of an elected official, and would like to have the opportunity, if council so chose, to place disclosure requirements on those entities. Regarding ballots, there are numerous places in our charter that prescribe the form of a ballot. These ballot forms made a lot of sense in 1914. A lot has changed since then, voting technologies. It simply does not reflect the way that ballots are currently laid out in the state of Ohio, and certainly doesn't reflect electronic ballots in the way that those would be laid out. So we recommend removing any ballot form that is currently in the charter, but including some additions such as a summary versus a full text of ballot issues, because that would provide us with the opportunity to save significant funds if a ballot issue question is put on the ballot before voters, would lead to a shorter ballot for them. We would also recommend retaining the ability of council to make future modifications to ballots by ordinance of council and also by a vote of the people via the charter. I can't imagine that this would happen, but if, for example, the General Assembly removed the requirement that candidates' names be rotated so that they have roughly equal placement across all ballots, council could come in and require that for municipal elections again. It's something that we've had again for 100 years, and we would want to continue to have that. With regard to nominations, first of all, we recommend removing quite a bit of verbiage in the current charter regarding our nomination forms and default to the state petition forms except for the provisions of our charter and city ordinance. I know that there's been some discussion about the number of valid signatures that are required to file for office in the city of Columbus. That was changed recently to 1,000 signatures. Prior to that, it was a percentage of all electors, and prior to that, it was an even larger percentage of all electors. Staff was asked to look into this issue. We benchmarked the city of Columbus against the other large municipalities in Ohio, and as a percentage of the electorate, our signature requirement is approximately 0.2% of all electors in order to have placement on the ballot. That puts us exactly in the middle of the pack with the other large cities of the state in terms of the numbers of signatures required. We recommend removing the requirement that signers pledge to support a particular candidate. There has been conversation, individual conversation with 3 separate commissioners on this particular issue since our previous meeting. Staff is now recommending fully striking that language. We had recommended following a general provision in state law that would have limited a person to signing a single nominating petition. So, for example, if 2 individuals were running for city attorney, they could only sign one of those petitions. I think it was well stated by numerous commissioners that in the spirit of nonpartisan elections and the removal of a requirement that an individual pledge their vote for a candidate, that allowing individuals to sign as many petitions as they felt necessary would be a good thing. So staff is now recommending that we fully strike that language from the charter.
Just to add a note of specificity to that, Brian, if I might, correct me if I'm wrong, we're talking about on page 4 of the initiative referendum recall and charter amendments, striking lines 31 and 32.
I have to turn over my page, sorry. Let's see here. I believe that's correct.
Lines 31 and 32 state, at each election, the electors voting therein may cast their votes for not more than the number of persons to be elected to the office in question. So we'd be striking lines 31 and 32 so that an elector in the city of Columbus could sign a petition for both candidates for city attorney, both candidates for city auditor, both candidates for mayor. should
Yeah,
they choose.
that is the language that we would be striking.
Thank you.
Yes.
I'm sorry, and I'm confused. As I read section 41, lines 31 and 32,
Hold on 1 second.
that pertains not to signing petitions, but to actually voting at the election, does it not?
That's my construction as well.
I'm sorry, I got the wrong line. Jeff, you're right. That's not the correct, those are not the correct lines we'd be striking.
I apologize, I turned to the wrong page as you were reading and answered incorrectly. If you look on, I believe it's page 6 of 21, it would be beginning with line 4. Current charter provision reads that such petition shall contain a provision that each signer thereto thereby pledges to support, and so on and so forth. We would recommend removal of that language from the charter. Yes, lines 4 through 8.
So you have already affected the concept of being able to sign more than one petition for an office?
Yes, that's correct.
Okay, thank you. Appreciate it.
Thank you.
And just one other question. I know in fact, Matt Damschroeder emailed me today about this. The petition, the charter language used to prescribe the form of the ballot and talk about write-ins, and of course, they had to do something weird with that, and we're taking all of that out. There still will be provision for write-ins under state law, correct?
That is correct. Rather than having what has been a costly and unique write-in provision in our charter, we would still provide for a write-in under state law.
Thank you.
Commissioner Dorian, did you have a question?
Thank you. My question regarded write-ins.
Okay.
It's been answered.
Okay, thank you.
Our next recommendation is removing an archaic requirement that candidates accept their nomination. This was originally based on the idea, as we shared previously, that there would be a groundswell of support and an individual would essentially be drafted to run for office. It's not a current provision in state law. It's really a formality at this point, and by using the state law petition form, the individual is already stating affirmatively that they intend to be a candidate for that office. So they have, in effect, stated on their petition that they wish to be placed on the ballot for that purpose. We also recommend adding to death and withdrawal disqualified as a condition for replacing a candidate in a primary or a general election. We also recommend using state law deadlines and processes for withdrawal and replacement. These processes have been updated much more recently than our charter has and provide some nuance, especially given the differences in circumstances that would arise in disqualification, for example, versus death of a candidate. Regarding petitions for ordinance, referendum, recall, and charter amendment, this is probably the area where we recommend the greatest changes to the charter. First of all, to bring some consistency, some predictability to the process for petitioning city government for a particular action. That would begin with the use of uniform general provisions, including a petition template that would be provided by the city clerk. This would in effect allow any Columbus citizen to go to the city clerk, say, I would like to initiate an ordinance, receive a petition template that would comply with state law and with our charter. That petition form would then be filled in by the individual and circulated as any other petition would. It would not be a requirement, I would note, but it would simply be something that would be available to any individual that wanted it. We would adopt a modified version of state law for municipal petitions, incorporating elements of state law for state issues into our municipal sections. Again, as we shared previously, the municipal sections have not been updated, most of them since the 70s, some of them since the 1950s, whereas state law provisions for state issues have been very frequently updated. So some of the particular additions that we would recommend, first of all, requiring that each part petition be circulated as a single instrument, that they be printed in a uniform color. Currently, state law requires for municipal ballot issues that language be printed in red on one page. That dramatically increases the cost of simply printing petitions for circulation, and it's also an unnecessary provision that is not required for state issues. We also recommend that a title be without argument and placed on the top of sequentially numbered pages so that when a petition is turned in, we can be certain that the signature pages purporting to support a particular issue do in fact support that issue. We have had instances where a petition was turned in and there was no title on the top of the signature pages. That makes it very difficult to know what was actually circulated as a single part.
Mr. Clark, Mr. Commissioner Dorian, I apologize, has a question?
Thank you. I want to make sure that I think this is a good idea, this preparation of a template for citizens to get a common form. But I want to make sure that that template would fall under the public records category where the government, whoever that person might be, would be required to, I forget the exact language, but promptly deliver the document, otherwise make it available, because that is something new in the petitioning process. So I want to make sure that it is required that government make it available upon request.
Do you have a response to that?
I would say as a matter of current practice, the city clerk provides on council's portion of the city website information regarding the various types of petitions, sort of a walkthrough, if you will, of how to do that process. We would certainly expect that this would be an item that would be added to that web page as well, so an individual could very easily get access to it. It's my understanding that this would fall under the definition of a public record and would be subject to the public record sections that we're talking about adding to the charter as well.
Mr. Cox, can you confirm that these documents will be a public record?
Yes, the answer to Mr. Dorian's question is yes, it would be a public record.
Thank you.
Thank you very much.
I believe I am at full text. So we're also recommending that the full text of the proposed item be placed on the petition. State law allows a referendum to simply reference the title and the date of passage of an ordinance and the number of that ordinance. Anyone who has either worked here at City Council or attended one of our scintillating Monday night meetings knows that the title of an ordinance may or may not give the average citizen a sense of what's enclosed in that ordinance. while it might be technically correct, that technicality in the language may actually be a bar to understanding what's being put before the voters. So we're recommending that the full text be placed just as the full text of an initiated ordinance would have to be placed on a petition. That's sort of a sunshine provision for Columbus voters and potential signers of petitions. And then lastly, for state issues, circulators have to affirmatively disclose any payment or promise of payment that they've received in consideration of circulating that petition. We feel that that is a good public policy process, and it's one that we would recommend including for municipal issues as well. Moving on to some other process questions or issues. So first of all, state law does not harmonize between a municipal ballot issue and a state ballot issue. There is a requirement in state law that you provide an itemized statement of any monies that you provided for circulating a petition. It has to be done within 5 days of filing that petition with a city or village. We're recommending that we actually combine a state law provision on the front end for state issues with the municipal provision on the back end for municipal issues. So that when you file your certified copy with the city clerk, you would also say, I intend to pay people for circulating this petition. That allows us to know as we review the petition when it's turned in that we need to pay special attention to those circulator statements as we validate the part petitions. Secondly, continue the state law requirement that on the back end, a person who's provided money or things of value would disclose that information to the city. That again allows us to go through and be certain that the circulator statements, which are signed under penalty of election falsification, were in fact filled out correctly. So this is not a new provision, it's a harmonizing of two existing provisions in state law. Currently, and this is an anomaly in the way that our charter currently reads, it would appear, and I will use the word appear, that an individual could physically withdraw a petition after it's been filed with a office of the city. Once something is filed with that office, it is and should be and should remain a public record. We're recommending that we clarify in the charter that once a petition is presented to a public office, whether it's the correct public office or not, it at that time has become a public record and cannot be withdrawn from that office. However, we would maintain the ability of the ballot issue committee to withdraw it from consideration by the city. It would simply require a statement of the committee of a majority of those members. They would also be able to withdraw it from the ballot. So even if council, for example, had found it sufficient and placed it on the ballot under state law, I'm blanking on the exact deadline for doing this, but I believe that it's somewhere in the neighborhood of 60 days or so prior to the election, a person can remove that item from consideration of voters. So we would maintain that ability as well. Right now, there is not uniformity in where petitions have to be filed, so we recommend providing that uniformity both for certified copies and for the final petition. Because the city clerk has the vast majority of the duties with regard to petitions, we felt that it made sense to have them filed there. Currently, I believe the state law states a city auditor or village clerk. We feel that the city clerk would be the appropriate place there. We would affirmatively establish the duties of the clerk, the city attorney, the council, and Board of Elections in processing petitions. We do not receive as many here at the municipal level as the state does. Sometimes we can go many years between petitions being filed, and it can feel like we're reinventing the wheel sometimes once it gets to processing them. This would allow us some certainty both for us and for citizens in that regard. State law would continue to control the circulation and validation of petitions with very limited exceptions. Those limited exceptions would be, for example, disclosing payment on the circulator statement.
Excuse me, Mr. Clark, Commissioner Dorian has a question.
Yes.
Thank you. I want to make clear, or be clear, there's always been a lot of confusion as to whether or not these petitions have to be filed with the city auditor's office. I know that's the Ohio Revised Code, and of course our charter is silent. So if we adopt this language in the charter, does that make it clear that it is not necessary to file such petitions with the city auditor? Mr. Cox?
That's my understanding, but I would ask Josh Cox to confirm.
Yes, Mr. Dorian, that's correct. It would trump any state code provision, so the charter would say you file it with the city clerk, that's where it gets filed.
Thank you. Thank you.
Thank you.
Two items, and these are things that are modeled under current state law provisions. The first is that signatures could not be collected prior to filing a certified copy. This really provides both us and citizens with a safeguard that the petition will be uniform in character, that there would not be any changes between that pre-certification petition that was circulated and the post-certification petition that circulated. We'd recommend that we provide 1 year after certification, after filing that certified copy, to file an initiated ordinance or charter amendment. And we would also recommend that we maintain the current state law and charter provisions that recalls and referendums would have 30 days to be filed after the date of filing a certified copy. Council, with the exception of recall petitions, would determine the sufficiency of petitions. Currently, there are some petitions where the city clerk is required to determine sufficiency. We felt that a body that is ultimately accountable to the voters should make that decision, the lone exception being the recall. And in that instance, our current charter provides that the city clerk determine sufficiency of those petitions. We would recommend continuing with that. It is conceivable that we could receive recall petitions for 7 members of council. I think it would be an obvious conflict of interest for them to say that they should or should not be recalled in voting to call for an election. Council would have to act by ordinance on all petitions, making clear the method of council action. And per case law, those ordinances would not be subject to the veto or subject to referendum. For initiatives and referendums, state law requires that in order to enact an initiated ordinance, you need 10% of the votes cast at the last preceding election for governor. Our current charter states that it's 5% of the last preceding general municipal election. This has the effect of giving different citizens a different set of standards when they seek to petition their government. If they come in after the mayoral election and for 2 years thereafter, they would have a higher bar in order to recall an individual. They would have a higher bar to initiate an ordinance. They would have a higher bar to initiate the referendum on an ordinance. If they came in after what we refer to as the off-year election, where the number of signatures can sometimes drop by 40%, those individuals would be able to exercise the exact same authority, but do it with a much lower standard. This can also create some confusion on the part of citizens seeking to initiate an ordinance because it's sort of, follow the rabbit hole to figure out exactly what applies in what instance. So we're recommending that we follow state law provisions, which gives you a solid 4-year window where you know exactly what is expected. This would apply to initiated ordinances and to the referendum and would be 5% of the votes cast in the last preceding municipal election for mayor. Current state law gives boards of elections 10 days to validate petition signatures. We would recommend maintaining that in our charter. Currently under our charter, council has, if I remember correctly, 10 days in entirety after the board certifies to consider the sufficiency of the petition and determine whether or not we'll place it before voters. That does not give us sufficient time to do our due diligence as a legislative body to consider an initiated ordinance. For that reason, we're recommending, first of all, that council be provided with 14 days after the board's report to determine the sufficiency of petitions. There is no state law standard for this, so this would essentially give us 2 full council meetings to consider the sufficiency. Then provide 30 days to pass or repeal, depending on the type of petition, or place it before voters. That 30-day period would allow us to have public hearings, to do our due diligence in terms of researching the proposal. We feel that it would be an appropriate opportunity to show our due diligence in considering what citizens have placed before us. We would also recommend that council must prescribe ballot summary language for these items in the ordinance that sends them to the ballot, and give council the discretion to prescribe arguments for and against, depending on the issue. Those arguments for or against would be attached to the text of the ordinance or the referendum, the ordinance to be repealed, and would be placed in every voting location in the city of Columbus. Then we would also recommend clarifying that these ordinances are not subject to the referendum. The annual appropriations of the city, currently the charter reads the annual appropriation ordinance. We clearly have more than one annual appropriation ordinance. We have our tax ordinance, the operating budget, the capital budget. This simply reflects the real world operations of council and nothing more. And then we would also state affirmatively that if we're passing an ordinance to submit something to the electors, it is not subject to the referendum. For charter amendments, and this is an item where there have been questions from commissioners, the Ohio Constitution limits our discretion in setting the number of signatures required to propose a charter amendment. It places it as 10% of the votes cast in the last preceding general municipal election. In a sense, that would have made sense in the early 1900s because not every city has a mayor, and you can't peg it to that mayoral election. But it's interesting that the General Assembly, in every instance, has pegged it to a 4-year term, and it's generally the gubernatorial election. So while we have to retain the constitutional requirement that signatures be 10% of the votes cast at the last preceding general municipal election, staff would recommend, if we had the discretion, to make it 10% of the votes cast at the election for mayor, so that we would have complete consistency in our charter. But barring the ability to do that, we would retain the constitutional provision. An initiated charter ordinance would be limited to a single subject. And then lastly, council would prescribe the ballot summary, and again, may prescribe arguments for and against to be posted in voting locations. Then we get to the recall. Our current recall provision is, I think archaic would be a charitable term. It requires that you collect a certain number of signatures. At that point, the city clerk makes copies of those, distributes them to the various fire engine houses of the city, and the captain of the fire engine house has to keep control of those petitions, and an individual can go sign at any firehouse. However, they can't be asked to sign, and you can't have any activity, I believe it's within 100 feet of the firehouse regarding that petition. There is, however, an odd footnote at the end of that section that says this is in addition to any other provision for recall under state law. So state law provisions also apply for recall in the city of Columbus. We feel that a modified version of state law would be an appropriate way to deal with the recall. This would maintain the requirement the recall petitions have to have 15% of the votes cast at the last regular municipal election that should read for mayor, not regular municipal election. That you cannot file a recall petition within 180 days of someone taking office or within 90 days of a general election for that office. That no more than 3 elected officials may be recalled at a single election. It's odd to think, but under our current charter, every elected official in Columbus could be recalled at the same time. We think for the purposes of continuity of government, that that's not a good provision. So we're recommending this. The city clerk would maintain his or her responsibility for determining the sufficiency of the petitions and would maintain the requirement that vacancies created by the recall would be filled as otherwise provided in the charter. One thing that's not addressed in the summary that has been asked regarding the recall, it does require that the city clerk, not the council, establish the date and call for the election. The purpose of that is to be consistent in an elected official being completely hands-off when it comes to a recall petition. And with that not-so-brief summary, I'd be happy to answer any questions.
Thank you, Mr. Clark. That was very helpful. Are there any questions from any of the commissioners at this time? That is an awful lot of information to digest. And again, this is the second presentation we've received on this topic, but it's appropriate because it's a very substantive area. So any additional questions for Mr. Clark at this time? Yes, Commissioner Dorian?
Thank you. In the summary, under the recall, it made a reference to the 15% of votes cast in the last regular municipal election. Do I understand your current recommendation, is that reference be to the last mayoral recommendation?
Yes, that's correct, Auditor Dorian.
Thank you.
Any additional questions?
Yes, thank you, Madam Co-Chair. And Brian, we talked about this before, but as I was reading the text of the amendments, there was one portion where it didn't say mayoral election, it just said last municipal election. And you said that is because it was a state requirement, a state constitutional requirement, and which election process does that refer to?
Commissioner Cabot, that would be the charter amendments, and the Ohio Constitution prescribes that
Very
provision.
good, thank you.
Well, I would entertain a motion at this time to move this language forward for consideration for a vote at the next meeting.
So moved.
Is there a second?
Second.
All in favor?
Aye.
Aye.
Opposed? Same sign? Motion carries. Thank you very much, Mr. Clark.
Thank you.
And next, we're going to receive a presentation on residency for city employees. As a reminder to the commissioners, this information was presented at the June 19th meeting, but there was enough discussion that we decided to hear additional presentation at this meeting. So at this time, I believe Mr. Long will be making a presentation. Hi, how are you?
I have a very brief statement for you. Per a recent Franklin County Common Pleas Court decision, the commission cannot enforce the city's charter-defined residency requirement. However, because state law does prescribe specific parameters for establishing legal residency requirement, it is still an option that we are considering. Because of the various parties involved and those possibly affected by these changes, we would ask for more time to be given to address all the parties and the issues concerned.
So could you repeat for me exactly what the
civil-
recommendation is?
I'm the Civil Service Director.
No, I'm sorry, I know who you are. What is your recommendation? Can you repeat that for me,
Oh,
please?
yeah. Basically, I was asking for more time so that we can address all the parties involved. I think there are a lot of people involved. It actually took the court almost 3 years to make the decision, and we've had a short period of time since that decision has come out to try to address all of these issues.
So you're asking this commission not to take any action on this
That's
provision
correct.
at this, during this, the time that we're convening and looking at it, you want to take this off the table?
That is correct.
Thank you very much.
Sorry about that.
No, it's okay. Any questions from any of the commissioners for Mr. Long? Yes.
Madam Chair, I would just ask mayors and council staff if you're in agreement with that suggestion.
Chairman Curtin, yes, we are in agreement.
Thank you.
Council is also in agreement with that recommendation.
Thank you. Commissioner Dorian?
Thank you. All due respect to the Civil Service Commission that enjoys a separate and distinct section in our charter with their responsibilities, but there are many other city employees, unclassified and so forth, who may not fall under that direct purview of civil service. So I'm hoping that those others will have some input into this drafting. Is that fair to say? Okay, thank you.
Thank you. Do you have a question, Commissioner Cabot?
So we've been asked to look at the charter in its entirety, and we know that there's one section of the charter that has been declared inoperable by state Supreme Court decision, and we've been asked to ignore that. Is that correct?
Are you talking about the Franklin County Court decision that I was just speaking of?
I'm sorry. It's not been, it is still subject to further appeal, is that correct?
Let me clarify with the legal position on that. The common pleas decision that Commissioner, or that Ms. DeLong was referring to is based on that state Supreme Court decision and applying it to our specific charter provision. And we did not appeal that decision by a common pleas court because I think it was accurate.
Well, I'm sorry, it just seems like we're not quite doing our job if we know there's a section of the charter that's been declared invalid and inoperable, and we just leave it stay. But that's just one man's opinion.
Mr. Long, do you have any response to Commissioner Cabot's concern?
I guess I wasn't asking that we leave it stagnant for any period of time, and I know you guys have a very short period of time that you're working on this. I just believe that there are numerous parties that could be affected by this, and I think we need input from all of those if we're expected to be successful when we take this to the ballot.
Thank you. Commissioner Curtin?
Thank you, Madam Chair. Do I understand correctly then that the commission is not being asked to ignore this proposed charter provision for the entire life of this commission? It's only been asked to ignore it for today?
That is correct.
Then I think maybe I was mistaken. So do I take that to mean there will be another presentation at the next meeting on this issue?
If I understand Commissioner Curtin's statement, during this particular phase of the Charter Review Commission, I believe it's staff's recommendation that this item be left off the table so that we can have a fuller discussion of civil service issues. I believe that Commissioner Cabot's point is well taken with regard to items like the public defender section, for example, in the charter that's clearly antiquated and should be removed, but that's a standalone provision, whereas the residency provision is certainly intertwined with a number of other important civil service issues that could be considered at the same time.
Commissioner Dorian, do you have a question?
Madam Chair, I guess I'm still confused. Mr. Clark, will there be a recommendation brought before the commission to address this residency matter? I know I was one a week or so ago that said, why not leave it the way it is? But I quite frankly have been convinced that my colleagues were more right than I was in that conclusion. So I am of the opinion that we've got to act on this. If we have an inoperable condition here, we should act in response to it. So I'm assuming there'll be another recommendation brought before the commission. Is that correct?
Commission Member, City Auditor Dorian, I think it is our belief that there will be a recommendation brought forward at some point in time. However, we believe that further discussion is warranted, with the various parties that are involved in this, including members of the Civil Service Commission, before we bring a complete recommendation to the committee for action. So at this time, we're just asking to, put this on the, table it, I guess, until such time that we can bring a comprehensive resolution or recommendation to the committee.
Commissioner?
I'm thinking, how many more meetings do we have?
I believe,
Counting this afternoon.
Will we likely have that recommendation?
our next meeting is, not counting the public meeting for this afternoon, is June 30th.
Right. So it is our belief that because of the time frame that this commission has to take action and to conclude your work for this year, we would not have a recommendation prepared in time, but it would be under further review, and our hope would be that a commission would be called back together, as we have done, in years past. We have called a commission back together to look at other issues, including the public defender and some other matters that just require more time on the staff side and involve so many other parties. Because of the complexity of those issues, we'd like to bring those forward in a separate, when the Charter Commission comes back together at a separate time.
Does staff have any idea how much more time is needed? Clearly, June 30th is not enough time, but do you have any idea of how much more time staff needs to bring forth some recommendations on this
Just
provision?
let me confirm with the Civil Service Director.
And if staff hasn't had a time to determine,
We
that's
haven't,
fair. We're
yeah,
just
we
trying to
haven't.
get some perspective.
Yeah, we have not had time to discuss this completely. It does involve a number of parties, including all of our labor unions and, staff, other city employees, and the Civil Service Commission. So my guess would be that we would need, the balance of the year at a minimum to finalize a recommendation, call the committee back together, and ask for some type of action.
Commissioner Curtin, did you have an additional question or comment?
Thank you, Madam Chair. I think the last give and take here clarified it for me. It sounds as though the administration and council and the Civil Service Commission believe that all the factors that need to be weighed and considered and debated are such that nothing is going to be forwarded to this commission soon in terms of a recommendation for change of the charter. I think Commissioner Dorian's comments are well taken. If we have a dead soldier in the charter, my sentiment would be to remove it. However, I'm comfortable not acting on this today. I would like, in the interim between now and the next meeting, to get some sense from staff as to how long a process they see this taking. And then I think the commission, the next time we're together, can discuss the sense of the 5 commissioners on what we should do.
There's some consensus among the commissioners that we get an update from staff at the next meeting as to next steps and how best to proceed and address this moot provision of the charter?
Yeah, yes, thank you. And if I might ask, Josh, so this is a moot provision of the charter. If it were taken out, there would still, and if it were taken out and state law somehow got changed, either legislatively or by the courts, could then city council by ordinance adopt some kind of a residency requirement?
Well, I think there's a couple options. It's not just a repeal or don't repeal option, because one option would be to replace it with something in the charter that comports with current state law. So that's one factor you need to consider. But before any action can be taken, the charter amendment would have, the charter provision would have to be changed. Does that answer your question?
Well, so, I think, so council could not take any action inconsistent with this charter provision, even though this charter provision has been declared invalid and unenforceable by state law and state courts.
Yes, I think that's accurate because it says unless otherwise provided by this charter, which limits it, and the charter provision wasn't held unconstitutional, it's just in conflict with state statute,
Right.
which was, the state statute was held constitutional. So it's kind of a convoluted
Okay.
legal issue, but I think that's, the bottom line is there's nothing that can be done by council at this point.
All right. The Charter Commission was given a charge which was pretty broad and a limited time to accomplish it, and maybe we won't be able to accomplish that full charge in the limited duration of our existence, and I guess I just need to get comfortable with that. Thank you.
Thank you.
Chair Moore, if I could, I believe that we had discussed previously that there is precedent in previous charter reviews like this one in 1993 and also in 1998, where there were issues of this nature that came up that were simply so unique and required so much time to adequately address that the recommendation of the Charter Commission was further study and action. So it could be an opportunity for this commission to express its sense that action needs to be taken and taken timely on this issue, but recognize that there is not a solution at this point. So staff offers that as a consideration for the commission.
Thank you very much. I think consistent with the feedback that's been received, at the next meeting, could we get some idea of what time is necessary, maybe even what steps need to be taken to bring this matter to closure, and then at that time, the commission can take action. Commissioner Tyler Lee?
I think the other important thing to add is if we go with the language that we have developed around just meeting once every 10 years or having a commission every 10 years, part of what staff brings back could be what that timing would look like, so we wouldn't have to wait for that 10-year period.
Thank you very much, Director DeLong. I don't think there's any action we need to take on that. So we'll move on to the next agenda item, which is a presentation on the inability of office holders. We received presentations on this topic on June the 11th and June 19th.
Thank you, Chair Moore. I would bring your attention to some updated language here based on the discussion at the previous commission meeting. If you look at page 1, line 22, there's an addition that states, or 6 months have passed. As previously provided, and as Commissioner Cabot rightly pointed out, there was no limitation on how long temporary disability could be declared for a given individual. Staff is recommending that there would essentially be 3 ways to effectively rescind a declaration of temporary inability. The first would be the actual act of rescinding it. The second would be the passage of 6 months from the date that that declaration is made. And the third would be vacating the office either due to resignation or some other mechanism. And then the other substantive change that we would bring your attention
Sorry, Madam
to.
Chair.
I'm sorry, excuse me, Mr. Clark.
Yes.
Commissioner
So,
Cabot?
and maybe you were going to go ahead and explain this, but so what happens if that 6 months has expired and the temporary appointment is then defunct?
So I think that is the point at which Section 5.2 would begin. So at the end of that 6 months, if the individual was still unable to discharge powers and duties, 5.2 would provide that there would be a 90-day period after which the proceeding in quo warranto would be requested by the appropriate city official of the appropriate official, either the county prosecutor or the attorney general. Does that answer your question? Or?
Well, I'm having a little trouble hearing what everybody's saying throughout this process, but, so you're saying that if a temporary appointment is made, it's good for 6 months, at which time it expires, and then if the office holder is still unable to perform for another 90 days, then someone would have to take an action someplace to vacate the office?
Yes, that's correct. And there is a provision in Section 5.1. Now, you will not see this in the council section, actually, because the council section is unique in that there is no acting office holder in the event of an inability. But you'll see in the sections for the mayor, the city attorney, and the city auditor a safety net that the fact that this has not been filed does not bar the appropriate official from assuming the powers and duties of office. So in the event of a national emergency, were the mayor unable to communicate with an agent, or were the mayor and the agent unable to communicate that inability, it would not preclude the director of public safety or service or the council president from acting in an emergency capacity in that period of temporary inability. So that's sort of a safety net, if you will, in those very unique situations. But again, to your point, if, let's say, office holder X signs a statement declaring that he or she is unable to discharge the powers and duties, 6 months have passed, that individual is still unable to do so. At that point, the person then acting as the acting office holder would continue to do so, and then after 90 days would begin this process for the writ of quo warranto.
And is that explicitly stated in here, or is that, okay?
Yes.
Okay.
And those are the extent of the substantive changes based on the conversation from last week.
Thank you very much. Are there any additional questions for Mr. Clark? Hearing none, I'll entertain a motion to move this language forward as the recommended language on this provision of the charter.
So moved.
Is there a second?
Second.
All in favor, state so by saying aye. All opposed, same sign. The motion carries. Thank you very much. Thank you, Mr. Clark.
Thank you.
Now we're going to move on to a presentation on office holder compensation. The commissioners will recall we received a presentation on this provision on June the 11th and June the 19th, and there were some additional follow-up research we asked staff to complete, and we'd like to hear the presentation at this time. Thank you very much.
So staff was asked to look specifically at cost of living adjustment provision that was recommended here in this language. We looked first at the previous 4 years. Were we to enact this in this year, that would cap annual increases at 1.92%. So that would be a roughly 2% annual cost of living adjustment that would be available for the 3 outer years after salary is set. Our feeling is that we lead by example as elected officials, and by setting the tone both for our unclassified and classified employees, that cost of living adjustments would be exactly that. It would be pegged to a real standard that represents a real increase in the cost of sort of that basket of goods and services that the federal government looks at for the average family. This would also allow us to have an honest conversation about base salary for elected officials during the Citizens Commission, so that their recommendation for that first year really does reflect where they feel that person's salary belongs. And we're seeing cost of living adjustments as opposed to step increases or raises during the out years. And lastly, elected officials are unique in that, unlike other employees of the city, they don't have a supervisor that can sit down and provide a performance review and make a merit determination on an annual raise. So in this instance, we feel that absent that ability, limiting in a very clear way in the charter the ability to increase out-year salary increases would be appropriate.
Mr. Clark, as a point of clarity, can you confirm how often this Citizens Commission is scheduled to meet to discuss base salary or to set base salary?
Every 4 years. So the process would essentially be that by the second council meeting of the year of that commission, the members would be appointed. They would have 3 months to conduct their work, to make their recommendation, and council would have 30 days to act on that recommendation after it was received. The recommendation would be limited to a base salary in the first of 4 years, and then a limited increase pegged to a cost of living adjustment for the next 3 years.
Thank you very much. Any questions for Mr. Clark?
Again, I continue to believe that this is the level of detail and nitpicking that doesn't belong in the charter, and if you're going to have a salary commission, you ought to impanel it and give them authority.
Commissioner Curtin?
Thank you, Madam Chair. I am very respectful of Commissioner Cabot's position on this. I think that generally speaking, putting too much detail in the charter is exactly right and is a well-taken proposition. In this particular matter, though, I think nothing is more sensitive for elected officials than having to deal with their own salaries. And we are not obviously absolving the council of passing the ordinance that would deal with their salaries. They would still need to do that, as well as set the salaries for the other city officials upon recommendation of this commission. I think as a matter of policy, though, having a statement that a base salary shall be set for the beginning of each term, and any increases following that can only be cost of living adjustment increases, would be a therapeutic provision in the charter, would set a tone along the lines of what Mr. Clark outlines. So for those reasons, I am comfortable with it being in the charter, although I would say, generally speaking, I do agree with Commissioner Cabot. This would be an exception for me, and I'd be happy to support this proposed amendment with the cost of living adjustment language in it.
Thank you. Any additional comments or discussion on this issue? Commissioner Tyler Lee?
I'll just say that I'm supportive of the recommendation.
Thank you. Well, at this time, and Commissioner Cabot, your comments were well taken. I know I had a lot of questions at the last meeting and just did not really understand what was being proposed. I didn't realize that the commission was going to meet as regularly as it did to set the base salary, so I had concerns with the COLA, but upon a clearer understanding of what was being proposed, I too support the language that is being put forth. So at this time, oh sure, Commissioner Dorian.
Thank you, Madam Chair. Mr. Clark or whomever can answer this question, I'm watching the timing of the meeting dates, and I'll use as an example, there will be elections in 2017, city attorney, city auditor, and three council members, I believe. And then it goes on to say the first meeting shall be in 2018. When would those, are we suggesting that you'd have people running for election not knowing what the salary of the office would be?
I think that's actually a very good point, Auditor Dorian. Currently, we have salaries set for everyone except for the mayor through 2017. The mayor's salary is currently set by ordinance through 2019. That's why our recommendation is that the first commission meet in January of next year, 2015, prior to the elections, so that we can establish those salaries through 2019. That would allow us to get through this next set of municipal elections and then consider in 2018 and every 4 years thereafter the four-year salary. We feel that that would also give the benefit of having a mayor who is in midterm at the time that this is done, and it would also give the benefit of other elected office holders placing their preferred individual and having their preferred input before council takes action on this particular issue. So essentially, we would have 2015 a recommendation through 2019, and then in 2018, we would have a recommendation through 2022, and then so on and so on.
But if you have folks elected in 17, they would serve in 18, 19, 20, and 21. Their salaries have to be set prior to 18.
You're correct, and those salaries would be set in 2015. That's our recommendation.
2015, and you're setting a salary out to 2021.
Out to 2018.
18, 19, 20, and 21. Hope they have a good crystal ball. I can support the resolution as presented. I think it'll be a challenge.
Thank you. I'm trying to get the sense of the commission. Do we want to have further discussion? Is it something that we can accept and move forward? I'll take your head nodding as an affirmative.
I would move that we move the compensation issue on to our final meeting as presented.
Thank you. Is there a second?
I'll second.
All in favor?
Aye.
Opposed, same sign. Motion carries. Thank you. And next, we are going to get a presentation on open meetings and public records. This presentation was given to us on April the 25th and June the 19th, and we asked staff to follow up and look at some additional items, and we're prepared to hear the presentation on that at this time.
Okay. If we could begin with public records, it was clear that we want to be as close to state law as possible. The common denominator, as we talked through this with the city attorney's office in state law, was making records available. So the modifiers for that really depended on how the records were requested, whether it was an in-person inspection or if it was a request for a copy. So our recommendation is that we would state for public records, the records of the city shall be made available to the public in accordance with the general laws of the state. I would defer to Chief Counsel Cox in terms of verifying that this does in fact appropriately reflect the state law provisions.
I have nothing to add to what Mr. Clark said. I think that's to keep it consistent with the 14943 language. I think available covers it.
Thank you. Any questions from any of the commissioners on this provision? Thank you, Mr. Clark. On to open meetings.
And then on open meetings, I'll just read this in full if that's okay. The public bodies of the city shall hold all meetings in accordance with the general laws of the state pertaining to open meetings. In addition to those entities defined as public bodies in the general laws of the state, an entity of the city shall be considered a public body for purposes of this section if its members are appointed by an officer of the city and the entity has been established and its members appointed for the sole purpose of advising any officer or decision-making body of the city. The substantive difference between this and the previous version is rather than appointment being by an officer of the city, the previous version said the mayor or city council. While we can't think in recent memory of a task force or a commission that was appointed in a manner other than by city council or the mayor, it could certainly be contemplated that that could take place. So we want to sort of future-proof this recommendation, and for that reason, recommend striking mayor and city council and placing officer of the city instead. And the remainder of the proposed amendment is the same as what we discussed previously.
If my memory serves me correctly, I believe Auditor Dorian made a comment at the last meeting about the Board of Tax Appeals or some issue regarding confidential information.
Yes, I did, and I think that has been addressed. First of all, income tax records are not subject to the
Chair Moore, I can address it. It's my turn to eat crow on that one. I was wrong when I said at the last meeting that the Board of Tax Appeals is a decision-making body subject to open meetings law. It is a decision-making body, but it's not subject to open meetings law.
Thank you very much. I appreciate that. Any questions on these two items? Commissioner Tyler Lee?
Just for clarification, who else is included in the terminology officer of the city attorney and the city auditor?
That's our intent.
Okay, thank you.
Thank you. I entertain a motion to move this proposed language forward.
So moved.
Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion carries. Thank you. And next, we're going to receive a presentation on prohibited use of public funds. And like the other items we're discussing today, we did receive presentations on these items on June 11th and June 19th, but had several questions that we proposed back to staff, and we'd appreciate an update presentation at this time.
Okay. So staff has come back with two options for your consideration with regard to prohibited use of public funds. I'll begin with option 2 because it is the simpler of the two and the more flexible of the two. Option 2 would make an affirmative statement that monies of the city cannot be used in a manner that's counter to the charter, to state law, or to ordinance of council. But then it places a duty on council to establish by ordinance prohibited uses of public funds and penalties for violation of the same. This would essentially give council the ability to enact a provision similar to state law provisions for the prohibited use of public funds, but it would not embed in the charter any specific provisions of state law. Option 1, on the other hand, would embed certain things that that council staff do believe rise to the level of being so important that they could be placed in the charter. Number 1 would be using these funds for the benefit of a political campaign. Number 2 would be using funds of the city to promote discrimination. And number 3 would be sort of a catch-all. And I would note that there is a drafting error in number 3. It should be communication before expressly. So the limitation in state law is using funds to communicate in a manner that expressly advocates for the nomination or election of a candidate, to communicate regarding an investigation, prosecution, or recall, and to communicate regarding the passage or defeat of a municipal ballot issue. And then B would be an affirmative statement of how city funds can be used, and that would is in keeping with current practice of the city, that the funds can be used to produce, present, and communicate information about the plans, policies, and operations of the city. I would echo Sherry Kish's comments at the previous meeting to assure those that are listening and following this process, the city follows state law even though we're not required to. So this would not be a departure from current city practice, but it would give the citizens of Columbus some comfort that we would continue to operate in that manner.
Thank you. Commissioner Curtin?
Thank you, Madam Chair. For Brian and Josh, then just to continue a line of questioning I had at the last commission meeting, this language would allow the city to do what it's done in the past in terms of producing brochures, for example, for public meetings by bond issue packages and so forth that are explanatory in nature, but the city would not be able to put public funds into funding TV commercials, radio commercials, political communications, urging the passage of such. Is that correct?
Yes, that's correct.
Thank you.
Any additional questions? Commissioner Tyler Lee?
Does staff have a preferred option of the two being presented?
I believe that from council's perspective, and based on a number of conversations that we've had internally and with the commission, option 2 provides much greater flexibility in terms of keeping up with changing times. The idea, for example, that a few years ago, the idea of a political contributing entity did not exist in the state of Ohio. It's now a political entity. So it's certainly foreseeable that there could be political committees that are not addressed here. It's certainly foreseeable that there could be other ballot access options for citizens that are not addressed in point 3. We could move more nimbly if we had option 2 in place.
We concur with council staff. We prefer option 2 as well.
Thank you.
Thank you. Was the commission comfortable moving forward option 2 as the preferred language for final consideration at the next meeting? And if so, I'd entertain a motion at this time.
I'm comfortable with option 2. I'd be prepared to move on that.
Thank you. Is there a second?
Second.
All in favor?
Aye.
Opposed, same sign. The motion carries. Thank you. And now we're going to move on to agenda item regarding qualifications. The commission received presentation on this item on June 11th and June 19th and asked staff to follow up on some issues and would be happy to hear an updated presentation at this time.
Madam Chair,
Yes.
forgive me for interrupting, but could I ask everyone to kind of stay close to their microphones? The acoustics here are a little difficult for us. Thank you, ma'am.
Yes, and thank you.
I always assumed I had a loud voice. So for qualifications, there was one particular item where, upon further discussion internally and with the co-chairs, staff did not feel that they had clear direction from the commission in terms of what they would like to see in final language, and that was with regard to limiting candidates for office to those who have resided within the corporate limits of the city of Columbus for not less than one consecutive year preceding the date of the regular primary election for such office. The remainder of the text is identical to what was previously discussed with the commission, but that provision would be added to the council, mayor, city attorney, and auditor sections if the commission wanted to move in that direction. Staff would simply state that this would follow general laws of the state with regard to qualification requirements, and this is an instance where the General Assembly felt it necessary to place their legislative intent in the revised code, and their intent was that an individual be able to demonstrate a broad and deep understanding of the community that they wish to represent prior to running for office. And with that, I'd be happy to answer any questions you might have.
Thank you very much. Any questions for Mr. Clark?
I'm sorry, so the state requirement for election to a non-charter council is 1-year residency?
That is correct. For a statutory city, the requirement is 1-year residency prior to running.
But the Columbus City Charter requirement heretofore has been only that they be an elector of the city.
That is correct, a qualified elector of the city
The net
of
effect of
Columbus.
that is that they have to have had residence for 30 days.
It would be 30 days prior to pulling the petitions
Okay?
for that particular office, so they would not be able to file a petition if they didn't have the qualifications to seek the office.
Commissioner Dorian? Oh, I'm sorry.
I'm sorry. I'm
That's
just-
okay.
I should not open my mouth before I think. I think with my mouth open. I think the current charter provision is sufficient, and I don't think it's been a problem. I think you have excellent city elected officials.
I'm sorry, I couldn't hear you.
I think we have, the history of the elected city officials in Columbus has been excellent, and they seem to have had a full understanding of what's needed in the city, whether they've lived here for 6 months or 6 years or 60 years.
Thank you. Commissioner Dorian?
I hope I'm on here. I'm having trouble reading these signals. First of all, I want to make sure that Mr. Cabot's comment about good elected officials in the city gets into our minutes. Quite frankly, I thought at our earlier meeting, last meeting, or maybe the one before, that we had pretty much agreed to not have this one-year requirement and to rely on our existing language. So I think, Jeff, you and I are in agreement on that, and I would like to see it that way. I'm not supportive of the one-year requirement.
Okay.
That sounds to me like a motion and a second for an amendment to delete the language on the one-year residency.
I would so move.
I guess I would ask before a second, is there any other discussion or any comments from Commissioner Tyler Lee or Commissioner Curtin? And I guess before you comment, I guess I would like to add, I'm in favor of the one-year residency, but Auditor Dorian, I thought your comments at an earlier meeting were very well taken as to things you can accept and things you can't accept. I don't feel so strongly on it that I could not accept taking it out, but I'm in favor of it. I don't think that it is asking too much. I think maybe the electorate might expect that, but I think your comments are well taken that we've had excellent elected officials. So I can accept it, but I'm in favor of having the requirement. Commissioner Tyler Lee?
I'm also supportive of the one-year residency requirement. I was not able to attend the June 11th meeting where I think you had more extensive conversation about it, and would just be interested, Auditor Dorian, from your perspective, why you're interested in striking the language and why the 30 days is comfortable to you.
Thank you, Madam Chair. I think history has shown that the current charter has worked well. I do not see any reason to place an additional restriction on people's eligibility to seek elective offices, whether it's here in Columbus or elsewhere. And when you think of having to be an elector before you even circulate a petition, you're at least 7 months in the residency of the city before an election take place, and then another couple months before you would take office. So I think the current charter has worked well, and I see no need for this.
Thank you for the explanation.
Commissioner Curtin?
I guess that puts me in the deciding vote category. And I think I would tend to agree with Commissioners Dorian and Cabot on this issue. I'm not sure what problem we're solving. I'm not inherently against a one-year residency requirement per se, but we have an effective 2/3 of a year requirement now, as Auditor Dorian points out. So I guess my sentiment at this point would be not to add a residency provision of 1 year to the charter.
And can I ask from the City Council and the Mayor's office, is there a position essentially that you could reiterate from both of those offices on this particular issue?
I think from council's perspective, we provided this as an opportunity for further discussion. We don't have, we're really neutral on this issue and are seeking the commission's guidance with regards to this.
The mayor's office feels the same way. We are just seeking guidance as we look at the charter, and as you look at the charter, we're seeking your guidance and input as to whether or not this requires a change.
Thank you very much. With that, I would entertain a motion to move language forward, not having the one-year residency requirement in, unless there's any strong objection from any particular commission not to. I'd be happy to hear that.
I would so move, not to have the residency requirement included herein.
Thank you. Is there a second?
Second.
All in favor?
Aye.
Opposed?
Opposed.
Duly noted. Motion carries. Thank you. Now we'll move on to a presentation on ethics. We have received presentations on ethics on June the 11th and June the 19th, and there was an awful lot of discussion about the word willful. So I'm really looking forward, and I'm sure the rest of the commission is, into getting a presentation today that will address the concerns presented by the commissioners at the previous meetings.
I guess I can, need to turn my mic on. I guess I could at least get the conversation started on this particular issue, and I'll leave the legal questions, and I think the bulk of the questions were legal in nature at the previous meeting, to the city attorney's office. But you have a completely revamped proposal in front of you prior to the previous meeting. This proposal would state that unless otherwise provided by this charter or ordinance of council, general laws of the state pertaining to prohibited actions by public officials as established in Chapter 2921 of the Ohio Revised Code or a successor thereto shall apply to the officers and employees of the city. Such prohibited actions include, but are not limited to, unlawful interest in public contracts, theft in office, soliciting or accepting improper compensation, and bribery. Any violation of this section shall constitute malfeasance in office, and any such officer or employee shall thereby forfeit office or employment. And you'll note on the handout for the commissioners that there's a little table there that includes the reference to the section in the ORC, the standard that the ORC applies to that particular item, and then the penalties in the ORC. For bribery and theft in office, the penalty is being forever disqualified from holding any public office, employment, or position of trust in the city. And then for unlawful interest in public contract and soliciting or accepting improper compensation, the standard is knowingly. One is either a felony of the 4th degree or a misdemeanor of the 1st degree. The second, improper compensation, is a misdemeanor of the 1st degree.
Mr. Cox, do you have anything to add to what Mr. Clark has just presented?
Now, I guess let me address the willful issue. As we were trying to come up with some language to address this, it occurred to me that part of the problem with the current language in 227 is willful is generally considered in the context of willful misconduct, and it's a tort standard. And we're dealing primarily with issues that are addressed in the revised code as criminal prohibitions. And the criminal standard for most of these, as Mr. Clark pointed out, for most of these offenses is knowingly. So you're kind of mixing apples and oranges if you start throwing in willful violations and you have a knowingly standard for the violation. So the way this is drafted, it would defer to the standard that is in the revised code for what constitutes a violation, and that in most of these cases is knowingly.
So the commissioners, and please correct me if I'm mischaracterizing this, was concerned that an employee would make a kind of unwitting or unintended violation of this law, would have to forfeit their office. What we didn't want is to get rid of a well-meaning official for maybe a minor mistake or that they didn't know they made the mistake. But is this being corrected by saying, because the standard is knowing, so this isn't the honest mistake, this is a I hate to use the word willful. I take that back, I strike that. So this is a knowing, intentional violation that causes the office holder to forfeit their office. Is that correct?
That's correct. It's, again, the standard is part of existing criminal prohibitions that apply to all city employees, all city officials currently. So it's not imposing any new duties on public officials. And in fact, I would argue that it actually gives more protection to the individuals in terms of you have to show a knowing violation, you have to prove it beyond a reasonable doubt, There has to be a conviction before this triggers the subsequent charter penalty of forfeiture. It also has the benefit of existing case law, which has explained these sections. You get advisory opinions from the Ohio Ethics Commission. You can consult the Ohio Ethics Commission if you have a question about these provisions and get an opinion from them that would provide immunity in the event that you follow that opinion. So I think it's much clearer, much more established duties that are imposed upon public officials and public employees if we refer to the revised code provisions.
Thank you. Any questions? Commissioner
Yes,
Cabot?
thank you. Thanks for all the work that you put on this. As I recall, previously, 2921 did not apply to city employees. Was that?
No, it does.
It does?
Yes.
Okay. And this...
It has and it does.
This makes our charter consistent with state law, and I may be the one that raised this question the most, but I am satisfied with the current presentation of it and would move, when the time is right, for us to move this forward to June 30th.
Thank you. Any additional questions or comments before we entertain a motion?
I would
Commissioner
agree.
Downey? Okay. Commissioner Curtin?
Just a clerical question, Josh. This chart showing the four-box layout, is that simply for our consumption, or would that box actually be in the charter itself?
I believe that's from the mind of Mr. Clark and only for consumption of the commission.
Okay.
Will not be in the charter.
No visuals in the charter. Thank you.
Probably best that my mind not be placed in the charter.
Thank you. Well, if there are no further questions, I think we're at the time to entertain a motion. Mr. Cabot?
I move we move this forward to June 30th.
Thank you. Is there a second?
Second.
All in favor? Aye. Opposed? Thank you. The motion carries. And next, we're going to receive a presentation on the council. We received a presentation on this provision on June the 11th and June the 19th, but asked staff to follow up on a couple of items. Thank you.
Thank you, Chair Moore. A number of these items we've already addressed today. For example, vacancy, temporary and permanent inability, qualifications, salary. So I'd begin with Section 8, which is on page 2, line 24. It was recommended, and we agree, that striking from our charter the specific process for calling for a special or an emergency meeting might give us a little bit of extra flexibility, and we would simply default to state law in calling those meetings. This would also reflect the new language starting at line 37 regarding availability of public records pursuant to general laws of the state, but would also provide that those records be electronic. Beginning then on Section 9, we would break out the current Section 9 into its various parts, beginning with the fact that council shall determine its own rules and order of business. Section 9.1 would establish that our journal is maintained as a permanent electronic record and that it's made available pursuant to general laws of the state. Section 9.2 would affirmatively state that council has the authority and it would recognize current practice of council to form and provide rules for special committees and standing committees, the purpose of which would be to promote the thorough and effective conduct of the business of the council. And I would just note that this does not place any specific council committee into the charter, nor does it require that council establish committees. It simply reflects our current process for organizing council, and it is a provision that is typically found in other city charters. Section 9.3 is a more expansive approach to the issue of expelling or punishing a member of council for specific acts, and this is modeled on state law standards and then moves a previous section about being absent from 8 consecutive meetings into this section. Council currently has in the charter a provision that any member who's been absent for 8 consecutive meetings forfeits office unless they are excused by a resolution of council. So we would maintain that provision here under the expelling, removing, and forfeiting office section. Section 10, as we noted before, would more appropriately address the current roles and responsibilities for the council president. Current charter provisions primarily speak to the council president's authority as presiding over meetings, being the presiding officer of the body. Really, this brings to light the fact that the council president really does set the agenda for our council meetings, appoints the chairs and members of council committees, and would perform such other duties, striking the term as presiding officer to give more latitude in council's authority to give duties to the council president as may be imposed by council. It would also address an open question, although one that we've been able to solve without this provision, but we feel that it would clarify this issue. In the event that the council president dies, resigns, is removed from office, ceases to hold qualifications, or the office is otherwise vacated during the term of the council president, council would have a new election for a new council president. 10.1 would reflect in the charter the fact that the council president pro tem is a standing officer as opposed to an officer that is appointed ad hoc in the absence of the council president. And then 10.2 would provide that in the very unlikely event that both the council president and pro tem were absent, that council would elect one of its members as the acting president pro tem. Section 11 we've covered fairly extensively in better addressing and better reflecting the powers and duties of the city clerk, stating what the city bulletin is because we referenced it in the charter but we never defined it. And removing Section 145 of the charter, which spoke to a Bureau of Information within the office of the city clerk. Really, those are duties of the city clerk, his or herself, as opposed to a bureau in that office. Section 13 would bring the powers and responsibilities of the city treasurer and would harmonize those with the powers and duties of the city clerk. Section 14 would clarify that council's limitation on the power of appointment is for officers or employees of the city. That was an unclear provision previously in the charter. We've spoken about Section 15 regarding compensation, so we can skip that. Section 17, we've recommended moving that council shall be the judge and of its elections and qualifications of the members, move that to a separate section. Section 18, I think the point was well taken from several individuals that the commission was not ready to consider a provision that council could place multiple charter amendments in a single ordinance. So we've simply removed that from consideration of the commission in Section 18. But would maintain the requirement that these council actions would be permanent electronic records made available to the public by general laws of the state. Section 19, line 10, would allow us to provide ordinance and resolutions that are introduced in electronic and digital form. While we have used our administrative code to define printed as a digital or electronic record, it would probably be more appropriate to clearly state that intent in the charter. Section 33 and 34 speak to council's authority for investigations, and here we're bringing our authorities in line with those of the mayor and of the auditor to appoint an individual to conduct that investigation on council's behalf. As currently written and read in conjunction with, I'm not going to try to remember the Latin phrase for that, but read in conjunction with the other section of the charter, it would appear that only a council member, his or herself, could conduct an investigation, and that council would potentially not have the authority to appoint a person to do so. So this would not really be a new thing. It would be providing sort of the same process for council as we have for those other officials. And then line 35, again, removes the bizarre phrasing that one would be excused from testifying touching the witness's knowledge, and instead say testifying regarding the witness's knowledge. And with that, I'd be happy to answer any questions.
Are there any questions from any of the commissioners? Commissioner Dorian?
Thank you, Madam Chair. A clarification. In the earlier draft of this document, the elimination of the, what's it called, Bureau of Information and Publicity was very, very specifically written out. Now, I notice that's not in this document, is it, the reference to the Bureau of Information and Publicity? I'm in favor of the original draft, but if we're going to move on this that's being presented today, should that not be included in it?
You're correct, Auditor Dorian, that was oversight on my part. Section 145 should be reflected here as being repealed as part of the overall package.
Thank you, Auditor Dorian, and thank you, Mr. Clark. Commissioner Tyler Lee?
In Section 9.3, expelling, removing, and forfeiting office, there is an acknowledgement of the permanent inability clause, but there isn't one of the temporary inability. Does one need to be there for temporary inability?
I think that's a very good question, Commissioner Tyler Lee, and our intent there was to reference something that could lead to the forfeiture or vacancy of office. The temporary inability could not in and of itself lead to that. So we referenced only the permanent inability in that section.
But could there be, and maybe I'm not understanding it correctly, but could there be an instance where a council member was in the temporary inability category and missed 8 consecutive meetings, but that wouldn't be cause for being removed?
That is correct. The only standard for removal in that instance, and it is unique to council, a council member could be removed from office for missing 8 consecutive meetings, but council's operation in the event of being notified, and that's actually part of where this temporary declaration came from, a council member would notify the council president for any meeting that he or she would miss. And there have actually been instances in the past, as Auditor Dorian has mentioned, where a council member was absent for a significant period of time, and council in each of those instances has passed a resolution excusing the member.
Thank you.
Any additional questions? If not, at this time, I can, one of two things. We can entertain motion to move this forward, taking into consideration Commissioner Dorian's comment that there is a provision or there's language that is missing on here that needs to be added, or we could table this until June 30th, at which time we could see the document with the language in here. And I do whatever the commissioners are comfortable with. I would be comfortable moving forward and just adding, with the understanding that we need to add that language back in because we've all seen that. And if the commissioners are comfortable with that, I'd entertain a motion at this time.
I would so move.
Thank you. Is there a second?
Second.
All in favor?
Aye.
Opposed? Same sign. The motion carries. Thank you. And if I am following correctly, the last presentation we have now is on Recreation and Parks. Is that correct?
That is correct.
Thank you. We look forward to hearing from you.
Thank you, Chair Moore. I believe the commission has previously received a presentation on the need to modernize the Recreation, Section 128, Recreation and Parks Commission appointment and organization. So I will skip down to the sections that we are seeking to provide additional clarification on, starting with, so option 1, you have 2 options before you, option 1 and option 2. Option 1, line 26, beginning with the word all. All commissioners shall be bona fide residents of the City of Columbus or Franklin County, Ohio, or counties contiguous thereto. We are seeking to modernize this portion of this this portion of the section of the charter to reflect the reality that there are residents who live within the city of Columbus who may not reside within Franklin County because of the growth of our city. Therefore, we are seeking to expand this category to include the city of Columbus or Franklin County or counties contiguous thereto. Option 2 is just a little different take on this same idea, and it reads, starting with line 39, all commissioners shall be bona fide residents of the city of Columbus or Franklin County, Ohio, or counties immediately contiguous thereto, provided that a majority of such commissioners shall be bona fide residents of the city of Columbus. This additional language reflects the concern from staff, mayor staff, and some Recreation and Parks staff that because commissioners are charged with dispensing rules, regulations, guidelines, permitting fees, et cetera, associated with our Recreation and Parks organization, and they greatly impact the residents of the city of Columbus. All but maybe just a few of our recreation facilities are within the city of Columbus. We felt that a majority of the commissioners who reside within the city of Columbus was appropriate at this time. However, we'd like the commission to be able to discuss both options and deliberate and take action. Thank you.
Thank you. Are there any questions for Ms. Angel regarding the presentation of Recreation and Parks? Commissioner Dorian?
I just want to be clear, is option 2 the preferred option, the administration and the Recreation Department?
Auditor Dorian, that is correct.
I am prepared to move this forward to the final consideration with option 2.
Thank you. Is there a second?
I would second that.
All in favor?
Aye.
Commissioner Curtin?
Thanks, Madam Chair. A question for probably Josh. When it comes to having residency requirements in the charter, such as this one or any others that might find their way into the charter at whatever time, and there arises a question as to whether a person, in this case, a Parks Commissioner, is or is not a resident of the City of Columbus or Franklin County. And an example would be someone who maintains multiple residences. Say someone is a Parks Commissioner, he or she happens to be a resident of Columbus, perhaps an elector of Columbus, but spends 6 months of the year in Florida or Arizona, or 7 months of the year, and someone were to raise a question, and this would to become a political issue, whether this person is or isn't a resident of Columbus, what's the default mechanism? Is it default to a high revised code for defining when one does or does not meet a residency test?
Well, I think in the absence of specific definition of that, we do have the provision in the charter that defers to general law of Ohio. There's also the argument that you default to the commonly understood definition of resident, which doesn't necessarily answer the question in that case. So it would probably, I think, in that circumstance, result in general law of Ohio in determining who is or isn't a resident. And I don't know whether that would be elections law or some other provision that would apply for that. That's a long-winded way of saying I'm not sure.
Thank you.
Commissioner Curtin, would you like additional research to be done on that issue before this language is moved forward?
Thank you, Madam Chair, but no, just curious. It's something that is not likely to arise, but could arise. It more likely arises in other contexts rather than this context, but we're going to be talking about residency rules, and it's something that could come up. I was just curious. Thank you.
Okay.
I'm prepared to support the motion.
If there are no further questions, Commissioner Dorian, could you renew your motion to move this language forward?
I move that this language regarding the Recreation and Parks Commission regarding appointment and organization be forwarded. Thank you, sir. Thank you. The Recreation Parks Commission appointment or organization language be forwarded to a final consideration by the commission and include option 2 as recited here regarding residency requirements.
Thank you very much. Can you renew your second, please? Second. Thank you. All in favor?
Aye.
Opposed? The motion carries. Thank you. Well, concludes the business that we had set for this meeting. I want to thank staff for the presentations, and I would like to thank the commissioners for input and attention during this meeting. Commissioner Dorian?
Yes, thank you, Madam Chair. I wanted to raise the subject on the last draft of the elections portion and so forth, indicated additional considerations. And it talked one bullet point about the establishment of voting as a fundamental right. And then a second bullet, which I'm very concerned about, indicated establishment of a sunset provision on initiated ordinances or referendum. I do not recall, where was that left?
Mr. Clark?
Yes, Auditor Dorian and Chair Moore, thank you for raising that. So we raised both of those issues as items for discussion with the commission, understanding that these would be seismic shifts in public policy here in the city of Columbus. First of all, declaring that voting is a fundamental right. While it is something that council staff supports, we understand that the implications of that are fairly far-reaching, and those are things that should be fully vetted in a process that would take much longer than the time we have before us now. With regard to a sunset provision for the initiative and the referendum, in our original charter of 1914, there was a 2-year sunset provision for initiated ordinances and referendum. I believe that it was 1933 where our entire initiative and referendum process was amended, and at that time that sunset provision was removed. While there is precedent at the state level for action to rescind an initiated statute very shortly after an electoral vote, we are not prepared at this time as staff to make any recommendation for amending the charter on this issue, but simply wanted to get the sense of the commission there.
Thank you.
Thank you. Any additional questions or comments? With that, I would like to announce again that we have a public hearing today at 5 o'clock, and speaker slips will be accepted until 5:30, and the next commission meeting is June 30th. Are there any closing remarks before I entertain a motion to adjourn? Okay, I'll entertain a motion.
So moved.
Is there a second? Second. All in favor?
Aye.
Opposed? Motion carries. Thank you.